Hello, everyone. My name is Farouk Abbas, and today I want to answer a very interesting question on intellectual property. Does your trademark registration prevent you from being sued for a trademark infringement claim or a passing off lawsuit? The answer to the question is no. There's a common legal misconception that once you have a trademark registration or a trademark certificate over a particular brand name, it means that you have a bulletproof vest against all forms of claim on trademark. But this misconception is very wrong because the fact that you have a trademark registration over a particular brand name does not mean you can be sued by another company who believes that you are infringing on their brand, on their trademark. So, for example, if you have a trademark certificate over the name Mango, what this means is that you have the exclusive right to use that name and that brand for your business. And this is covered under the Trademark Act. However, if the design, the logo, the get up, the color of your brand or your product imitates another company's product, especially if the company is well established, or infringes on the trademark of another company, then in that case, you'll be exposed to a lawsuit for trademark infringement or passing off. So this means that before you decide on a brand name or to register your trademark, you should do your due diligence, even in the market, to be sure that whatever it is you are designing does not infringe on somebody else's brand. And this fact, this situation I've just spoken about, arose in a recently decided case at the Supreme Court in the case of DKGO Motors versus Allied Signal, where a company who had several trademarks sued another company for infringing on their trademark and for passing off their own products as theirs. And when this company filed the lawsuit, the other company, the defendant who had a trademark over a particular brand, felt that because they have this trademark over Allied, that name, then they shouldn't be sued. And they brought an application that the court should dismiss the lawsuit based on their trademark certificate. And the Supreme Court, the Federal High Court, the Court of Appeal, and the Supreme Court held that no, the fact that you have a trademark certificate doesn't mean that if somebody sues you for infringement of trademark, then the case will be dismissed or you can't be sued. No, once they sue you, you must go through trial and you must establish your trademark. And if the other party is able to establish the fact that you've infringed on their trademark, then you'll be penalized for that. So, in summary, let's not assume that the fact that we have a trademark registration automatically means that we can't be sued by somebody else, especially where they believe that we have infringed on their trademark. Thank you very much.